Good morning. My name is Justin Audu Ebute, and for the purpose of this interview, I have chosen Express co-ownership as the topic I'll be looking into. I have chosen this topic because it involves two or more people, which can be easily related to our everyday life on how we can peacefully coexist. Except that this time, it's in regards to how to legally coexist in the same property under law. We're going to be looking closely at why co-ownerships were needed in the first place, hence they were created, as well as when and how they were brought into the law of land. There has been a couple of reasons in the past as to why co-ownership should exist and be bound by law. One of the main reasons would be because relationships tend to break down between people, and then a big fight about who owns what and who has the right to what becomes a problem. So this can be seen as one of the main reasons co-ownership is being recognized by law. There are a number of situations where it may become necessary to establish the actual beneficial ownership of land. Quite commonly, the issue will arise when the relationship of whatever nature between two people breaks down, and then the question will arise as to between them who owns what, or on the death of one of them who owned what. Also, because there are different kinds of relationships that exist between people, the judgments in regards to co-ownership will vary because the court won't treat a situation involving friends the same way as that involving direct family. Other important factors we'll be looking at will be in regards to the concept of joint ownership as well as the concept of sole ownership of legal title. This will help us look into the two forms of co-ownership existing today, one being joint tenancy and the other tenancy in common. Another aspect of importance will be disputes, as this is the reason why co-ownerships are made so as to avoid disputes between parties. Mainly, we'll be drawing comparisons between the two forms of co-ownerships in order to identify which form suits best for any situation. The two forms of co-ownership are one, joint tenancy and tenancy in common. There used to be four forms of co-ownership that existed back in the day at common law. The first one, joint tenancy. A joint tenancy indicates that the co-owners are holding the property concurrently. The co-owners are to be treated as a unit, whereby each co-owner is entitled to the whole property. Some features of joint tenancies involve joint tenants having interest or rights and not shares in land. And also, if two or more people have a joint tenancy, they will be regarded and treated as one person under law. Joint tenancy has these two main features: right of survivorship and the four entities. Right of survivorship. On the death of a joint tenant, his interest does not pass under the law of succession, but rather passes to a surviving joint tenant. This simply means that if, for instance, three people had a joint tenancy and one dies, the interest of the deceased will be passed to the surviving joint tenant because, as mentioned earlier, once a joint tenancy has been agreed upon, no matter how many people are involved in this joint tenancy, they will be recognized as one person under law. Therefore, the interest or rights of the deceased cannot be passed to someone outside the joint tenancy except the deceased specifies in his or her will that they want their interest in that joint tenancy to be passed to whomever they want. The four unities. The four unities are always in existence as long as a joint tenancy is in question. These four unities must exist between the co-owners because for a joint tenancy to be valid, it must possess these four unities. The four unities are unity of interest, unity of possession, unity of title, and unity of time. If any of these four unities are missing, a joint tenancy will not exist, and rather a tenancy in common will exist. So therefore, all four unities are as important and must be together as the name implies, unity. The unity of possession can be referred to as the cornerstone of co-ownership, as without it, co-ownership doesn't exist. Co-ownership exists with respect to a piece of land only if unity of possession between two or more people exists with respect to that piece of land. There is unity of possession if two or more people have concurrent rights to enjoy the whole of the relevant piece of land. For unity of interest to exist between two or more people, there has to be the same interest in land between the co-owners. There have to be consistently similar rights in the land in question. For unity of title, this simply implies that the people under the joint tenancy must have acquired their interest from the same deal or document. Lastly, as for unity of time, for there to be a joint tenancy, the right of each tenant must vest in interest at the same time. Put in more everyday language, the right of each joint tenant must commence at the same moment. Tenancy in common. Tenancy in common was predominant in the early 20th century. There are a lot of differences between the joint tenancy and tenancy in common, and this breeds from the fact that each tenant is viewed as his own person, unlike the joint tenancy, where all tenants are viewed as one. Each tenant in common owns a separate share in the property. That share is not physically demarcated, and that is why a tenancy in common is often referred to as an undivided share in the property. It is perfectly possible and indeed not unusual for these shares to be of different proportions. One of the features of this is no right of survivorship. If a tenant in common dies, there is no right of survivorship. For instance, Austin, Bella, and Chambers were tenants in common, and Austin dies. His share in the property will be passed according to the law of succession and not to the other tenants in common per his will. Unity of possession is another feature of tenancy in common. Unless it is physically partitioned, each tenant in common has the right to occupy the property. One tenant in common does not have the right to exclude the others. This unity of possession, is the only unity necessary for a tenancy in common. Now we'll be moving on to the features of joint tenancy and tenancy in common. As we'll be trying to choose the better option between these two, we'll have to use life scenarios in selecting which tenancy suits the best for each scenario or the person in each question. So as to understand what you should be looking for should you have to decide between joint tenancy and tenancy in common. The features of joint tenancy. Married couples tend to benefit more. It is more suitable for a married couple to engage in a joint tenancy because in marriage generally you are coming together as one, and this concept seems to be the same behind the concept of joint tenancy, as all tenants under joint tenancy are seen as one. Another feature will be shared responsibilities between tenants. Tenants under joint tenancy have a shared responsibility between them because they are all viewed as a collective. When a married couple or two business partners jointly own an asset, it is called joint tenants with the right of survivorship. It simply means that both individuals take responsibility for that asset and they both enjoy what it has to offer and share in any responsibility equally. Also, this shared responsibility goes as far as even when the property is sold. The shares of the property will be split equally by the tenants, regardless of who brought the most capital. Another feature will be the fact that it helps to avoid probate. If a tenant under a joint tenancy dies, his or her will be taken to a probate court where it will be assessed. The court decides if a will is both legally binding and valid, as well as determining the value of assets and liabilities. Once the review has been completed and any debts have been settled, the remainder is distributed to their heirs. Right of survivorship. Usually when a person dies, the family or friends would have to wait for the probate court to make declarations before being able to use whatever assets the deceased left behind on passing. But if there is a joint tenancy between the deceased and say a family member or spouse, they can do as they please with the assets. as it automatically becomes the joint tenant. This particular feature is why each joint tenant, to each joint tenant holds nothing and yet holds the whole. The last feature I would like to mention will be notices to quit. Everything that can be entered into should always have an exit, and joint tenancy is no different, but it has to meet specific criteria. In the case of Dodi, Aslin, and Somerset, one joint landlord had served a notice to quit, which was seen as and held to be successful by the court to terminate the lease, even though the other party had no idea of this. The reason for this is that where there is a periodic tenancy, each successive period operates as a renewal of lease. The case of Harrow London Borough Council and John Stone is also another very good example on how to notify a joint tenant before quitting. Features of tenancy in common. Shares must not be equal. Any percentage can be established when entering a tenancy in common. This simply means that there can be a wide discrepancy between how the property was paid for between the tenants. For instance, if A, B, and C buy a land, A can provide 50% of the money, while B and C bring the other 50%. Whatever profit realized from this will be split the same way it was bought, meaning A would get 50% of the profit, while B and C will share the remains. Another feature will be shares are passed through their heirs. In a tenancy in common, if one of the tenants in common dies, then his shares of the property will be passed according to his will, directed by a probate court, and not automatically to the remaining tenants in common as seen in joint tenancy. Another feature will be every owner owns an asset. In tenancy in common, every tenant owns exclusively the amount of shares he paid for or the percentage provided. There can be a boundary set up between tenants in common from allowing fellow tenants make use of whatever assets they own, unlike in joint tenancy where everyone owns everything as a collective. Another feature will be notice to quit. In tenancy in common, any party can part with his or her share legally without needing consent or approval from the other parties as to when he or she wants to leave. With all this being said, the conclusion will be if anyone wants to go into a joint tenancy or a tenancy in common, it will be reasonable to look at your situation before deciding which way to go, because it all depends on what situation you're in at that moment, because that determines the best way to choose between a joint tenancy and a tenancy in common. Thank you.